Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the latest episode in our Building Better Boards and Leaders podcast, where we examine the key issues facing boards and executive leaders. I'm Susie Leask and I'm a corporate and commercial partner at Hall & Wilcox and co-lead of our Beyond Compliance initiative. Today we're talking about employee fraud and corruption and what boards and management need to know when responding to these allegations or claims, and also how to take steps to prevent or mitigate these types of risks to the business. I'm delighted to be joined today by my fellow partners, Julian Hammond, partner specialising in commercial disputes and regulatory investigations and co-lead of our ESG practice, and David Catanese, partner in our employment and workplace relations team, who regularly advises on workplace investigations, complaints and grievances. Thank you both for joining us.
Thanks, Susie.
Thanks, Susie.
Let's start with you, Dave. We've seen a number of high-profile cases and examples in the media recently in this space, and a few that we've all seen cross our desks too. What are some of the key workplace issues that arise when an employee or a CEO is accused of fraud? And what are some of the key structures and processes that boards can have in place to deal with instances of alleged employee fraud?
Thanks, Susie. Yeah, it's certainly and unfortunately an emerging trend where we are seeing more and more employee-related fraud. And we're seeing that across all levels of organisations, from fairly low-level employees who have access to financial information or a role in financial processes, all the way up to senior executives who have more influential or decision-making roles. And everything in between. It's a really complicated for organisations when they see that something's not right. We got some instructions from a client recently where they had received an email from a supplier, which went something like, "I'm really sorry to tell you this, but the invoice you sent to us isn't one of ours." And all of a sudden, there's action stations, and what do you do? And so going to your question about, well, what are some processes that boards and organizations can have in place? Well, the first thing is don't panic. Don't panic. This happens all the time, unfortunately, and there are some pretty tried and tested ways to manage these situations. And so it's don't panic, take a deep breath and think about what to do next, because often where we've seen organisations in real trouble, it's because they've acted quickly in a way that can't be undone later. For example, you think somebody's done the wrong thing, if you've got very good evidence of that, terminate them straight away. Well, then your ability to extract information from that person evaporates at that time. Maybe there's a better way to do it, put them on ice, remove their access, and you can get information from them later that might really be helpful. Focus on what the key interests of the organisation are in that circumstance. And we would say that the number one interest should be what's happened, how do we make sure this isn't getting worse? If there's a leak, how do we plug this now so it doesn't get worse? Secondary, will work out how to take action, punitive action against people involved and recover losses and things like that. But first of all, let's work out what happened so we can plug the gap. And you don't want things to get worse. And it can get worse in a number of ways. People can keep taking money, but there are other issues as well. Reputational issues are huge. Other liabilities, do you need to report to insurers? Is there going to be internal communications and reputational issues? Do you really need to lock this down? You need to come up with a comms strategy and a risk strategy very quickly. And all of that points to getting your advisors in very quickly. And just on the comms point as well, it is really important to control who knows about these types of issues, particularly where there isn't good intelligence at an early stage about who might be involved in any potential fraud. For example, are there people involved at a high level who might influence how an investigation and mitigatory steps about these measures goes. And obviously you'd want to exclude those people. So really locking down who knows about the issue to those who are in the tent and part of the decision making.
That's some great tips there, Dave. And I think that's a really great point about sort of not reacting emotionally and jumping to conclusions as well. I think from a board perspective, that's really critical, that those decisions are being founded in fact and on the basis of actual evidence. And certainly it is a process that you do have to undertake carefully, so you don't, as you say, end up blowing it up and making it worse than it could have been. And Julian, I'm interested in your thoughts and perspective as a litigator and an expert in regulatory investigations as well, which can often be a flow-on effect from some of these things. And when we're potentially talking about white-collar crime and fraud, which might have broader impacts than just for that individual.
Yeah, thanks, Susie. Look, this is in part, I think the uptick in this space is what I really categorise as one of the wonderful post-COVID problems, in that obviously being inside for a number of years and people working remotely without intensive supervision in an environment where we were, largely had to be reactive very quickly, has probably led to a number of issues that are suddenly starting to really get an uptick now. And certainly we've seen publication of that in a number of stories in the media, whether through CEOs or employees more broadly. And then, also, running the gamut from, some of the issues that were raised, at a late stage in the Bruce Lerman proceedings, defamation proceedings, as you would have seen some of arguments about misappropriation of funds in respect of employees there as well. More broadly through to CEOs, as I said. And I think that's kind of, in terms of a contextual issue and why we're seeing this uptick now, a large part of it probably is a lack of oversight that occurred within that COVID period, and the fact that now, certainly as we are entering into a higher interest rate environment and certainly a slightly more revenue constrained time for a lot of firms, people are starting to look at the books a bit more closely and think exactly what's going on. And or more importantly, I think, as Dave alluded to in his particular example where I assisted with him with that particular matter as well, someone pops up and says, thanks for this invoice, that's not one of ours, and that doesn't make sense. And then an investigative process starts from there. So, certainly there's a contextual reason why this is kicking up. But from our perspective as a litigator, I'd really emphasise and echo the comments that David made about, certainly taking a strategic and not a reactive approach to issues. Termination of an employee, referring matters off to police for investigation, that will really prejudice your ability to start looking at recovery and the various mechanisms that are available to you. Certainly some of the things that I would be saying is, often in cases of employee fraud, there's obviously a civil remedy and a criminal remedy that you can pursue, and the pursuit of, referring a matter off to police to investigation may ultimately be where you get to. And that may be because civil proceedings are futile, because the misappropriated funds have been spent, and, an individual's likely to be made bankrupt in respect of, any proceeding or debt recovery. But there are very good reasons why civil proceedings should be pursued, and you should be strategic about considering this as part of the investigative process at the employee level, the information gathering process, and then strategically working out how the organisation will respond. Because if you refer matters off to police, your likelihood of getting, recovery will be severely diminished. But if you are able to ascertain where the funds have likely been spent, where they currently sit, then you have the chance to preserve improperly obtained property, even to recover misapplied funds, or at least those that have not really been spent, and to claim equitable or other interests in property obtained through the fraud. And certainly, there have been interesting and relevant examples of that recently in the media, including executive assistants to CEOs of banks in Australia, and certainly a number of reasons why civil proceedings should certainly be at the forefront of any organisation's mind in terms of trying to think through the potential avenues. There are really, there's really important types of relief that are available to people in that civil recovery space. There's freezing orders, also known as Mareeva orders, and that can freeze someone's assets and make sure they can't be dealt with other than in accordance with court orders. That can freeze bank accounts, that can freeze property interests of ex-employees, and that will really assist you in preventing the dissipation of misappropriated funds. If you've got enough evidence and if you've gone through the information gathering process and, as Dave said, put someone on ice, potentially got some information out of them rather than terminating them abruptly or swiftly, then that can also empower you to get search orders, also called Anton Pillar orders, and that can have the purpose of securing or procuring evidence, and that can allow you to enter into an ex-employee's residence and search the ex-employee's home to obtain documents, computers, other evidence relevant to the fraud. And certainly courts are pretty willing to use those orders to assist an employee to recover from an ex-employee who has defrauded that business. So that's really, there are definitely options available to people in that space. And again, just to emphasise the point that David made, that to be strategic and have a process and not be reactive will enable you to keep that suite of options available to you. From a broader regulatory perspective, there may well be instances where disclosure to regulatory organisations or a broader communication process is important. Now, it wasn't strictly employee fraud or misappropriation, but obviously, there are examples in the media, in terms of how recently in the inquiry space, particularly related to disclosures and secrecy obligations in relation to tax consultations, that I think raised some questions about, knowledge of the board about employee conduct, or in that case, partner conduct, and how you deal with that. And certainly, being on the front foot about disclosure about matters more broadly can assist in managing reputational and regulatory risk. But again, the key message here is to be strategic and methodical and not reactive, emphasising and echoing the point that David made.
And I think those range of options available that you've just mentioned does show how layered this issue is, and I think how you do have to be really careful and targeted in how you approach it, and, as you say, not reactive. And I see boards struggle with that because often some of these things all happen to happen quite quickly and quite simultaneously, and in order to figure out the best course of action to stem the bleeding, so to speak. And I wonder as well, from a board perspective, some of those other impacts that I see, whether it's in the whistleblowers space, where often it can be the board member that's been alerted to this issue and told something confidentially, and then have to really consider, well, who do I tell and how do I manage this and what's our policy? And so there are a number of minefields that you've got to be careful not to step on, and other impacts as well that I've seen around loss of funding or government contracts, where that trust and reputation piece comes in as well, that, well, maybe your financial accountability systems and protocols are not quite up to scratch. And how does that affect your other stakeholders, and the comms piece that David mentioned, which I think is really important. That's where we'll leave this episode. If you enjoyed today's episode, stay tuned for part 2, where we will touch on what directors can do to try to prevent employee fraud and corruption from occurring, how to implement a strong workplace culture of integrity and transparency, and provide some tips on how to deal with worst case scenarios. Thanks everyone for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or follow our podcast wherever you get your podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.